very much, ladies and gentlemen. Welcome. Thank you for being with us this afternoon. Just after lunch, it's a challenge. We'll try to make it lively and make it, let's say, interactive. Yesterday, one of our dignitaries cited the French philosopher René Descartes, cogito ergo sum. I think, therefore I am. Very good citation. So today, let's think together. Today, let's be together active as members of the international IP community. So very much welcome to you all. Today we are going to think together, to reflect, to exchange about the evolution of the patent legal system in Europe. In 2023, we have seen the long-awaited birth of a new type of patent system in Europe. The Unitary patent, UP, a new patent court, the Unified Patent Court, the UPC. That will be the subject, the topic of our exchanges today. My name is Olivier Corticchiato, difficult to pronounce indeed. I am a European and a Swiss patent attorney. I spent about 16 years of my career with Procter & Gamble, with P&G. I spent then about 15 years with Nestlé in Switzerland, where I was leading the Center of Competence for Patent Conflicts. Today, I am an independent IP, intellectual property consultant, and I provide guidance to my clients on several topics to make sure that they use, let's say, they make the right decisions for their IP assets, that they have the proper IP strategy, that they have the proper IP governance, and they use wisely their IP budget. That's what I do for my clients. Together, today, I have the honor to be accompanied in this panel by Carl Richard Haarmann from Baumert & Baumert. And Carl, very much welcome. Carl is an attorney at law, practicing and handling many IP litigations. He gives regular lectures and seminars on commercial legal protection. He has handled already some cases in front of the UPC, or for the UPC. And he is also a visiting professor at the University of Qiantang in China. On my left, I am accompanied by Fritz Wetzel. Fritz, very much welcome, from Black IP. He is a German and European patent attorney specialized in chemistry and life sciences. Fritz founded his own law firm, Black IP, and which provides full IP services on patents, trademark, and designs. To my left again is Martin Schwartz from Black IP. Martin is a general manager of Black IP. He is a keynote speaker on intellectual property and specialized in managing IP portfolios. So very much welcome to all of you. Some logistics first of all. We will start with a formal presentation that you will see on the screen by Fritz and Martin, covering all the, let's say, main aspects, an overview of the main aspects of the UP and the UPC. Just to make sure that we have a common general understanding on the UPC matter. They will show as well some statistics on the first 9 months of that new court on new European patents, of the new system. And it will be very interesting to have that and to then reflect on that. We will follow by a hopefully lively discussion on exchange on specific aspects of the UP and UPC. I hope the session will be very much interactive. So we are in a small room. Don't hesitate to ask questions, to interrupt us, and we'll make it all lively. We have a 2 hours slot. We won't need the 2 hour slot. We will see as it goes, but I want to make sure that we have enough time for our formal and non-formal exchange. So let's kick in. In June 2023, as I said, we have got a new European patent, the UP, Unitary Patent. We have got a new patent court, the UPC, the Unified Patent Court, and that works in, if I'm not wrong, 17 European countries, which are fully part of the system yet. What does it mean? What does it mean for us? What does it mean for legal practitioners? What does it mean for companies? You know, patent litigations are very simple. Maybe you won't contradict or you will contradict me, but in theory they are very simple.
Very simple.
Very simple. Basically the questions are, is that piece of land, that building, that IP asset a property? Does it define as a property, an intellectual property? And that's the question of getting a valid property, a valid piece of IP, a valid patent. That's a validity question. Second question is that land, that piece of land, that building, yours? Or is it maybe not yours? So that's the questions about IP ownership, inventorships as well. Third question is, did I trespass your property? Did I enter your land? Did I enter your building? That's the question of patent infringement. Another question is, was I allowed to enter your property, to enter your ground? So that's the question of licensing. Did I get the authorization for doing what I was doing or not? That's the licensing questions. And another one is, did I make unduly profits from entering your property? Did you lose some business by the fact that I entered your property? And that's a question of damages. So that's all very good and very significant questions in IP litigations. All these questions have to be considered nowadays in the framework of the new legal system in Europe, the UPC and the UP. So we need to have a new look to make sure that we know the new rules, to have a new look, to change our practice, to have this new legal system and framework in mind. So what to do? How to adapt? How to be proactive in as patent proprietor or in our practice? That's all the questions that we are going to cover today. So with that introduction, I'm glad to pass you the floor.
Carl, you want to talk now a little bit about the Unitary patent system?
Yes, I believe most of you will have seen slides like that already. So the system is set up in a way that we have the central chamber, we have local chambers, and we have regional chambers. And basically, you can bring the case to, in most cases, you will have the choice where you wish to go, because there's a big option for forum shopping. It depends maybe on the place of infringement. You can sue and litigate there. So we have also for this would be the counterpart of infringement. That would be the negative declaratory action, and also actions against rejection in European patent proceedings. There is also optional proceedings that you can bring to the Unitary Patent Court, and that is for already existing EP bundle patents, which have been validated in at least one member state. That means you can automatically go to the Unitary Patent Court, but you can opt out, and of course I believe that was the topic which has been discussed most hotly in the years prior to the coming into force of the Unitary Patent System, opting out yes or no, and I believe this is a topic that we will discuss later. Advantages, of course, you have one court and you can cover right now 18 countries, with a big likelihood that more countries will follow. So in the end, the idea was, of course, to have one, let's say, European patent, which would be enforceable with effect, cross-border effect in all European countries. Nowadays it's limited to 18, but more to come. And you have infringement proceedings and validity proceedings handled by one court, which is at least a difference to the German system. And the initial idea was probably to have a better effect and to save costs. Because of course, if you can save, like in former times, at least in theory, you would have to go to several courts in several countries to enforce your patent. Nowadays, you could save the cost for that and go just to one court and enforce your patent in one action. We will see if this is actually going to happen, because we have to bear in mind the national systems are still in force and they are still active. And in Germany, of course, at least, still more cases are being infringement cases are being filed with the national courts, with the desired effect only on Germany, but still parties prefer to do that compared to cases going to the UPC, which may have advantages but also have disadvantages, and we are likely to discuss that a bit later. I'm not sure if we should dive any deeper into proceedings before the court. I'm not sure, maybe question to the audience, because I don't want to tell you stories that you know already. I'm quite sure that for the last 3 or 4 years, many presentations have been made already on the unitary patent system. So, do you already have an idea how these proceedings are actually working, or is that something completely new to you? I don't want, there's a saying, don't carry owls to Athens. So, don't tell stories which everybody knows already. So,
maybe you can give a quick overview about the proceedings, the procedures.
Okay.
Very short,
Yes.
just to make sure that we have a basic common understanding on that.
I'm going to depart a bit from this slide. The way how a patent litigation case at the UPC actually starts is the plaintiff needs a unitary patent, of course. So then he chooses the court. He can sue the defendant either at the court where this defendant has his address or business seat, and alternatively he can sue at the court where the infringement happened. Most likely it's going to be the second choice, of course, because then you can pick the court. You start the case by filing your complete case. It's an electronic filing system. You have to upload all the documents. We'll talk about the difficulties involved there later. The case will be served to the defendant, and then a very strict regime will start by the court. The court has basically the obligation to come to a judgment within 1 year following the filing of the suit. 1 year is actually quite quick, especially if you bear in mind that this will involve not only infringement proceedings but also nullity proceedings, so the counterclaim. So what happens is the defendant is being served with the case and he gets a 3 month deadline to file not only his defense but also, if he wishes to do that, but of course most people wouldn't wish to do that, his counter action for revocation. So 3 months' time is very short. The plaintiff then has the chance to respond once, the defendant has a chance to respond once, and then there will be a preliminary hearing by the judge rapporteur who is following up with the case. This will be about claim construction, it will be about interpretation of certain aspects of the case, and the idea is to give the parties direction to the important topics of the case. So to focus the discussion on the very important aspects and to sort out those aspects which may just be like a big wall of fog which is being produced by the defendant or irrelevant arguments being used by any of the parties. So following this session, there will be another set of writs to be exchanged, and then we will have all oral proceedings already. So this is going to happen within 1 year. The deadlines are very tight, and it's not very likely that anybody will be able to obtain extension of terms. So you must do your homework, and you must do it very quickly. And this will be one aspect that we are going to discuss a bit later about costs. So once this judgment has been rendered, it's preliminarily enforceable. You can pay, the winning party can pay a security bond and then enforce the judgment already. I doubt that this is very likely to happen, but could be a nice pressure tool, especially for winning plaintiffs. But of course the case can go to appeal to the Central Appeal Court in Luxembourg. There's no tight deadlines for the appeal court, but at least at the beginning of the system, where we do not have too many cases, it's likely that the appeal court is also going to be very quick. So it's not unlikely that within 2 years or so, we will have the first cases with a final decision rendered by the appeal court, which is fast actually even compared to Germany, which tends to be very fast, but 2 years for a full case is already quite a challenge actually. So this is how proceedings, the main proceedings are happening. There is a possibility to file an independent revocation action, and that's the big reason why people were opting out if you own a unitary patent or a patent with unitary effect. Even if you have not started litigation, but of course an infringer, potential infringer is fearing to be attacked, what he can do is he can file the central revocation action. Can only be filed with the central chamber, not with the local or regional chambers. But all of a sudden you end up with your patent being at stake, and this is a patent not only for one country, but for 18 countries. So this is the main reason why companies have chosen
not go via UPC. So I think there's some insecurity in the mind of the companies at the moment that they better won't opt out and wait how the UPC works before they try this one single shot, as Carl talked before, one single shot, and you have a counterclaim for invalidity, and you lose maybe a blockbuster patent at the end.
Yeah, that's a very good point, and I think that's a crucial point about the risk, and we will discuss that a little bit later. So please go on.
From these 48 counterclaims that have been filed, it has to be noted that this a little bit inflated because it come only from 18 real infringement actions, because there are sometimes many parties involved in one case and file the counterclaims. That's why these counterclaims are not present the correct number at the end. Here is the statistic again. Cases with a counterclaim and cases without a counterclaim. This is not important here. What is interesting is the language of the proceedings is that German language is still predominant with 49%, but English coming up with 40% of the proceedings, French only 4%, Italian 4%, Dutch 3%. So predominant, as it was before, also are the German cases. And this is something maybe Martin can tell you now, because we yesterday we figured out the cost of the proceedings before the UPC. I think this is a crucial question at the end, and it was not so easy to figure out, but we did it yesterday. Martin maybe won't talk about this.
Yeah, I'll give a short introduction, and surely Carl will share some of his insights. He has already some actions and some experience there. From just the rules on the cost. Court costs in the UPC court are 20,000 euros flat for any infringement case and also for the counterclaims. So this is not depending on the value of dispute, but the recoverable cost from the other party, recoverable lawyer costs, are dependent on the value of dispute, and in comparison to in comparison to the German case, it's very similar for equal value of dispute. On the low end, the UP costs are slightly higher than in German court proceedings, between like 8 million to 50 million. The German costs are higher, but for the UP, there's a category over 50 million value of dispute, and then the attorney fees that are recoverable surpass the German recoverable fees. What is interesting to note, we have compared equal value of dispute, but this will not likely be the case for comparable proceedings, because if you have only a claim in Germany, the value of dispute will be looked at how big is the market in Germany, and if you go to the UP court, the question will be how much products can be sold in the 17 countries participating. So the value of dispute will likely be 2 times, 3 times, 4 times, even 5 times higher. So maybe just pass over to Carl. We discussed over lunch some things there.
Yes. You've been talking about court fees and recoverable costs, but I believe there's still, and concluding from these statistics, one might assume that costs for litigation based on a unitary patent before the Unitary Patent Court are basically similar to litigation costs in, let's say, litigation in one country only, be it France or Germany or any other country. I believe it could be expected, and at least my experience confirms this expectation, that the real costs for UP litigation tend to be much higher. Not because of the higher value of dispute, you're absolutely correct. That's what I hear from judges at unitary patent courts. They say, okay, the patent has a higher value, and also the effect of an injunction has a higher value, so the value of dispute might be estimated to be higher. But this only refers to recoverable costs. In effect, the real costs for the parties will definitely be much higher compared to the cost of one country, single country litigation, simply because of the factors that I mentioned earlier. Proceedings are going to be much more intense, and you will definitely need more workforce, more manpower to handle this case. At least from my experience in litigation in Germany, same for France, same for Benelux, usually you would have maybe one patent attorney, one lawyer, and maybe both have one assistant working on a case. And this can refer to a big case. Depends, of course, but this would be the standard setup for a normal patent litigation case. In UP proceedings, this won't work because of the very tight deadlines, because of the combination of infringement case and revocation action. The problem is actually if you start thinking how to prepare this type of case. Being the plaintiff, of course, you must get your stuff together. That's normal. You have to file, to prepare a writ of claims, which needs to be quite comprehensive, even more comprehensive compared to what we are used to doing in Germany. You have to actually submit all the documents, all the evidence already with your first shot. So that may require a bit more work compared to a national case. The problem is, of course, that you have to expect the defendant to file a revocation action within 3 months of being served with the case. So, and you can bet that a revocation action will happen, because that is still one of the most effective defense measures a defendant. So I have to try to make a good guess on this revocation action. What is going to be the prior art? What's going to be the relevant attack? And you have basically to prepare your auxiliary claims and your defense arguments already before you have started your infringement action. At least for Germany, that's quite unusual. So this would involve a lot of preparatory work that you have to do even before filing the case. you need manpower for that, you need time to do that. And then you file your action, you are happy, but now the defendant is not happy because he has to prepare his defense within this 3 months term, and he has now to get his stuff together to file the revocation action. I'm not a patent attorney, but I guess doing the research, collecting all the prior art, and preparing a reasonable revocation action, and also he has only one shot. So again, this will require big teams and a lot of night shifts until you really have successfully prepared your defense and counter action. And this will continue because you only have this 1 year to go through all the case, which means that we will probably end up with teams, with litigation teams, which are comparable to the teams which have been common in the UK already for decades and in the US as well. But of course, in these countries, we do have much higher litigation costs compared to countries like Germany. So this is going to be the real cost. And now, to conclude this, actually talking about refundable costs, the winning party gets cost reimbursement, but only as far as the court deems them reasonable. So now we come to discuss. In Germany, it's easy. We have the value of dispute and a fixed attorney's fee. So I can only get that no matter how much I actually charge my client. This will be the amount of money that he's getting in reimbursed if he wins. So the Unitary Patent Court will have to make a decision on reasonable fees. So they do not only have to fix the value of dispute, but they also have to decide, oh, this lawyer, Haarmann from Böhme, he charges 700 euro per hour. And he charges not only for himself, but only for I don't know how many assistants. And each of them is billed with 350 euro. So is that reasonable? And from what I heard from UPC judges, they have a tendency to believe that lawyers are overpaid anyway. So they will probably cut down on these reimbursable fees. And this will actually increase the cost for both parties. Even if you win, you cannot expect to receive, like in Germany, about 80% of the cost of the money that you have invested in the case. And then you will only receive 40% or so. And this is, of course, also something that parties, if they have to decide to go to the Unitary Patent Court or not, they will have to bear in mind. It's definitely going to be more expensive. And that's a bit contrary to the initial intention of the patent system, of the Unitary Patent System, which was meant to make it cheaper. I believe it's going to be more expensive, and that's also a reason why most likely it's the big companies who will choose their crown jewels, their most important patents, to enforce through unitary litigation, whereas the smaller companies, or the less important cases, or the cases where you believe I can achieve the same effect if I just go to the national court, they will not go to the Unitary Patent Courts.
Yeah, thank you, Carl. I think what you said is extremely important. It is maybe one of the key messages that we want to pass through, indeed. You described it very right. The UPC, the new court, is very fast and efficient by design. But there is a counterpart to that, which is that, all the work, or most of the work, as you described rightly, has to be done up front, so front-loaded proceedings. And it means that it will be, if I put myself in the shoes of a patent owner, it will be more expensive at the end of the day. More expensive, but the counterpart of that is that you have a decision that does not only cover one country, but covers 17 or 18 countries indeed. So that's maybe one of the key messages here that we want to pass in that respect. You want to add anything on that topic?
I wanted to make a comment also on Carl's comment about the cost that you say it's more expensive. When you look on this slide here, this is just a comparison between one UPC case and a German case. But when you multiply this with many countries with different jurisdictions, then you're much more expensive than with one UPC case. So I think at the end it's not 100% correct to talk UPC maybe become more expensive than 5, 4, 5, 6, 7, 8, 10. or 17 national litigation cases. So
direct response. This never happens. And of course, we all know this never happened in the past. Even the big cases, if it comes to litigation in Europe, you will file in maybe one. In many cases, it's sufficient to file action only in one country, because you will have an effect in all other countries, and we all know that many courts are following leading decisions issued by Düsseldorf Court or also courts in other countries. So in the past, to my experience, even big and important cases, they were limited to national litigation in one country only. Of course, it happened, especially in pharma cases, that you would have to litigate in, let's say, 3 or 4, but definitely not in 10 and certainly not in 17 or 18 countries. So I believe still the calculation is correct, saying that it may make a lot of sense in certain cases to invest the additional effort and cost to actually use the unitary patent court system. But in other cases, from an economical point of view, it will still make a lot of sense to limit litigation to 1 or even 2 national cases. Of course, we do have cases where we have already, and that was the first case that I started. At that time, we had already gone through litigation in 3 EU member countries: Germany, Benelux, and no longer an EU member country, UK. And we had contradictory decisions from all 3 countries. So in one country we had patent valid and infringed. One country, patent invalid but infringed. Next country, patent valid but not infringed. Okay, and then you stand there and say, okay, what should we do? And that's the point where you can say, okay, now we want to have this one unitary decision. We want one decision on the validity and one decision by the same court on infringement. After that, at least we'll have certainty. So that's one of the situations where you would recommend to a client, okay, just take the money in your hands and make sure that you get one unitary case. But in many other cases, it's still definitely cheaper to go to a national court. To being accused of infringing a unitary patent. Depending, maybe you are a company and you are based in Benelux, small market, but you are successful there, and you are being attacked on the basis of a unitary patent. The litigation costs will be much higher if you need to defend, and this gives probably this will provide some different way of thinking also for defendants if they really wish to take up a fight. I know, for example, that German medium-sized businesses, they have no difficulty in defending against a threat with patent litigation. Usually, of course, if one of the big shots is coming along, they will think, should I really start a fight with them? But usually, if you believe I have a good defense argument, you can easily enter into litigation and not being afraid of it. If you are being sued by one of the big shots who are owning the unitary patents, with the threat of going through litigation at the unitary patent court, this is a different piece of cake, and you will have to reconsider if you really can afford to defend and if you wish to defend. So that might be an argument, just to turn it around, for unitary patent owners. Using patents, for example, as a tool for power selling licenses. A unitary patent is likely a better tool compared to 2 or 3 national patents as it used to be in the past.
Thank you, Carl. Yes.
I can only add on this, Carl is completely correct, but as a patentee you should think about how strong is your patent. When you look your prosecution history and not have many X documents, not many documents against novelty and related step, and you get it granted, you can expect you have a very strong patent. So for you, no problem to have your patent afterwards, because maybe you survive also revocation action at the end, as you would survive a opposition proceeding. If you have a weak patent, like the big companies always have, when they only have the add-on, then it's always a question of inventive step, and these patents are not very strong at the end. So for these patents, it does not make sense to make the UP. Better they opt out. Otherwise, it's a question of the financial strength of a company, because as Carl talked already, can be quite expensive to come in a UPC case at the end. So you have to compare the strengths of your patent, the importance of your patent for your company, and your financial strengths. And this should be decisive at the end, what you make, stay in the UP or opt out or make something else.
Thank you, Fritz. Very good considerations indeed. We are in the middle of the conversation on advantages and disadvantages of the new system. I hope that we answered your question. Do you see any other advantage and disadvantages of the new system? Can you elaborate on that? We have mentioned the cost. We have, on the positive side, mentioned the geographical coverage. Do you have anything else to add on this advantageous balance, and in particular on the administrative burden and the, how should I call that, the difficult start of the UPC administratively?
Yeah, I'm happy to share something about this specific topic. We've talked a lot about litigation costs, and only one in about 100 patents goes to litigation phase. So what applicants face in the first instance is what is the cost of validating a UP patent. And with the UP patent you save a lot of translation costs, administrative costs, compared to filing a bundle patent in 5, 6, 8, 10 of the member states. So you can already save like 5,000 to 10,000 euros just for the validation, and later on another 5, 10, 15,000 on annuity payments throughout the lifetime of such a patent. So for many companies, this can be a cost saving and also a saving in administrative work and cost.
That's a very good point indeed on the cost saving. Well, on the other hand, it does not take into account the fact that over the years you prune, you tailor your patent portfolio as a patent owner, and with a unitary patent, actually you cannot do that. It's either on or off. You abandon it or you keep it alive. Whereas on the overall portfolio, you can select over the years and decide to shut down one country or another country, let's say the validity of your patent in one country or the other country. That's the pruning effect that is possible with the old national system, which is less accessible for the UPC. But very good point. Anything?
Yeah, I must say, we are talking now 5 years about the UPC before it came into force. Now it came into force half year now. We started getting first experience, and at the moment it looks for me personally, as a patent lawyer, it's not a substitution of the common European patent. It's a second way at the moment to save costs, to get a patent for 17 member states. At the moment, hopefully become more member states in the future, but it will not substitute the old system at the moment. And I can see it from the numbers, from the statistic, what we figured out, that all the companies, all the inventors, all the patentees sit in the pole position and wait what's going up with the system. We don't know it 100% at the moment same. We try to find out, figure out, and we make our experience at the moment. That's why we sit here and try to give our first spotlight on the EP system and the UPC system. But we cannot taught more at the moment because it's just a half year. So we are in the children's shoes at the moment, same as you are, and you're waiting for information. Every information we have, we give already, and if you have more questions, please, audience is open.
I think we have one question here, please.
Myself, Dr. Haarmann, I am working for Zydus Life Sciences Limited. So my question is with respect to two points which has just came before the thrombotic drug was invalidated by UK court under G221, that is a plausibility clause. The same patent was held valid by the Netherlands court. So the innovator BMS was able to injunct the generic filers, but not in the case of UK. I will just ask the question that what are the advantages and disadvantages of UPC. So one point which I could remember is that the disadvantage is that if this could happen under the UPC, then if the one court or one jurisdiction has invalidated the court patent, then it has a concluding effect on all the jurisdictions. So you lost patent in all the UPCs where you have validated. Is that correct? And your takes on G221, like possibility going future, how further how it would be impacting?
Yeah, thank you. That's a very good question. Indeed, so far, we have two legal systems in place: the national courts and the UPC court. And we are going to learn, and I think that the judges will as well establish the case law in the best way, and hopefully we won't see much discrepancies in the decisions. But there is a risk indeed, and I think that risk exists for companies, for patent owners, of having contradictory decisions, and this will complexify the matter indeed. So that simplification I was talking and referring to about before will come long term, but in the short term, it's relatively uncertain. And uncertainty is maybe one of the other messages that we want to convey to you. We are learning, the new system is being built, the case law is being built as we talk, but it means that it is not yet fully established, and nobody knows, so uncertainty is high. You want maybe to
maybe one additional aspect, at least to my knowledge, most of the judges, the full-time judges on the Unitary Patent Court are at the same time still serving as judges in their national courts. At least in Munich, Mannheim, Düsseldorf. So not all of the judges in Düsseldorf are German judge and UPC judge at the same time, but some of them. So, and of course they stick to their legal education. That's going to be a problem, because maybe a French judge and a German judge will have a different position on certain issues, especially if it comes to certain aspects in patent law which have been interpreted in different ways in European countries. But still, it's the same guy or same lady sitting there one day with the German judge's robe on, next day with the UPC, and actually they will not, I believe all the judges who have their minds in place, they will try to avoid contradictory decisions. But still we have two systems in place, and this is maybe for lawyers and patent owners, that can be a technical choice, because as Martin said, you can choose, and you can use this choice to set up your strategy for litigation. You might decide first to go to a national court, and if this doesn't work, you still go to the Unitary court, or vice versa. It's two different patents you are using. So that is one point. I would like to make one more comment about what we know already about the Unitary patent system. Number one, the system has been coming for 25 years. Actually, I believe Europe has discussed about something like that for the last 50 years already. So, and actually, when I started 27 years ago, it was already in discussion, and nothing came out, and I thought that I would not have to work with that system within my time of my professional career. Now it's there, suddenly, because of the political decision, despite Brexit. So that's a big achievement. And despite many people had doubts if the system would come, if it would actually be successful and survive. I strongly believe it's here to stay. It's not going to go away. My personal expectation would be it's going to be a bit like the introduction of the European trademark. So in the beginning, nobody was sure if the EU trademark would be a success. And it's been an enormous success. Of course, the system is a bit different, but everybody, after some time, realized this is the tool that we all want to use. Still, national trademarks are available and they are widely used, but the EU trademark is the trademark right that you need to own. And the same will, I believe, apply to the Unitary patent. It's there. It's going to be an alternative tool, but in the long run, let's say in 5 to 10 years, it's going to be the main tool, at least if it comes to litigation. One second aspect, referring to what I said about defendants and plaintiffs, I believe it's a bit unfair because the system is clearly made for the strong ones. It is a disadvantage for the wealthy companies, the big shots, and because it's expensive and complicated, it's easier to administer, but it is, I believe, a bigger threat for the small ones. So defending may become more difficult, attacking may become for the strong and wealthy companies, it may become easier. That may be good if you're a big company. If you're a small company, or if you tend as a lawyer to represent small entities, maybe a disadvantage.
Thank you. Perfect transition, Carl. Thank you for these considerations. Perfect transition to the next question. Oh, please go ahead.
I'll take your points and could be helpful to understand this. But two quick questions from that. One is from the list which you are just displaying. No Spain in that currently. And UK, in any case, after Brexit, has to be managed differently. So in both these circumstances, top 5 EUs, there are only 3 in this. So one has to have a different strategies for Europe, Spain and UK, and for the rest of the 3. That is one thing. So the cost would vary accordingly. And second, with respect to the cost of dispute, which you just displayed a few slides back. So what is the reasonable way of, it is necessary to estimate the cost of dispute, and based on that the further costings are done in European litigations, or it is just a way of looking into this? Because in other jurisdictions, to my little understanding of US or Indian, there is no estimation of what is the reasonable cost of dispute, and then the other costs are being calculated. So can you just elaborate on these two?
UK is out. Of course, nobody knows what's going to happen. Maybe in 10 years' time they will be back in. I don't know. This is mere speculation. Spain, I believe, is very likely to join shortly. Of course, I've not spoken to anybody in the Spanish government, but the Spanish are keen to join, I believe. I also believe that behind the scenes there is some dispute going on, and that is about bargaining about the third central chamber. This is about